Harry, we are talking about quite a complex legal issue that is actually fairly common. It's this concept of a non-disclosure agreement, an NDA. Can you just start by explaining what exactly an NDA is if anyone listening hasn't come into contact with it?
It's really interesting that you touch on the idea that it's quite common because we actually don't really know the extent of how popular NDAs are because it's a secret deal by its very nature. But we do know from the legal experts and the advocates are telling us that it's starting to crop up in a lot more circumstances in workplaces. And let's just take a step back. So an NDA is a non-disclosure agreement, which is also known as a confidentiality clause. It's basically where you're legally obliged to keep a secret. I probably would have been bad at that in high school. They have been used in the business world quite a bit. So think about Coca-Cola. The recipe for Coca-Cola has been a secret for more than 100 years because people that have worked in the industry have had to maintain that secret by signing an NDA. But it's crept into other forms of agreements, and this includes cases where workplaces are handling sexual harassment.
Okay, and so in this context, you're saying that an NDA is being used by businesses when there is an alleged sexual harassment case at work. Can you just explain a bit more about that?
So if an employee brings an allegation against a colleague or a boss relating to sexual harassment at work, one option that they have instead of going to the police is to settle the matter within their workplace by receiving a certain benefit, which is usually a financial payment. But the parties could also agree to something like an apology. The catch is that the parties then need to all agree to keep quiet about the allegation itself. So this means that someone who's experienced sexual harassment who has made the complaint is prevented from saying anything negative about the workplace or the perpetrator in the future. And so sometimes NDAs are time limited, so they end after a period of maybe a few years, but sometimes they are lifelong. There's just no end to the non-disclosure agreement. So now NDAs can be beneficial because it means that someone who never wants to go public about the allegation, who wants to maintain their own privacy, has the option to do so rather than going through maybe a court process. But there is growing concern from legal experts, from the advocates who are saying that NDAs are being increasingly used to immediately silence people before they've even had time to think about a potential course of action that they could take. And this is where the Victorian Government comes in. They want to make some changes to ensure that this doesn't continue being the standard practice. Premier Jacinta Allan, thank you so much for joining the Daily Aus.
Great to be back with you, Harry.
So, Premier, what do you see as the main problem with the way that NDAs are used at the moment?
Well, the challenge with NDAs, and this comes, my information comes from listening directly from victim survivors, people who have experienced sexual harassment at work and then have had to be, in effect, re-traumatised by going through the NDA process. It silences victims. It silences victims. So it's not designed to address the issue in the first place, which is to address the harassment in the workplace. There are examples of where NDAs can have been misused in those employment processes. And that's why I'm determined to look at what we need to do to go further here in Victoria. It's a complex area of the law, but we know that this is an issue that must be addressed. And that's why we are undertaking consultation to look at how we need to see NDAs not being misused in instances where people have experienced sexual harassment at work and then go on to be re-traumatised through the NDA process.
So in Victoria specifically, 2 years ago, the Labor government had said it was undergoing some consultation. So can you give me a bit of an update of what your government's been doing in the last 2 years?
Look, this is an incredibly complex area of law, and what we have been doing over that period of time is listening to the voices of victim survivors, also to listening to other organisations in the communities, businesses, lawyers, unions, to look at what we need to do to strengthen this area of the law. Now, it's also, Harry, I think important to remember that for some victims, they may want to retain the choice to have an NDA in place to protect their privacy or whatever their personal circumstances might be. And we've got to recognise that where it's appropriate, where it's been undertaken in an appropriate consultative way in the workplace, that may be appropriate. But the evidence that we've collected over this journey shows us that too often they are being misused. The consequence of that is that the voices of victim survivors are being silenced.
So we're up to another phase of consultation. How long is that going to stretch out?
So we're releasing a discussion paper through our Engage Victoria website, and it will be open for a number of weeks. And we want to hear from a broad cross-section of the community. There will be the mechanism for victim survivors to provide their information in a confidential and an anonymous way, because we do want to hear from their lived experience, because we know this is being used in many instances as a tool to silence victims. And the consequence of that is we are not hearing directly from them enough about what we need to do to improve the processes into the future.
So how long do you anticipate that will take?
Look, we'll collect, obviously, the 4 weeks period for the consultation paper will be open. We'll consider that, and we'll need to then look at what further action we need to take off the back of that advice. I don't want to put a ceiling on that, Harry, because this is complex. I think if you look around the world, there is, I think there's a bill in the Irish Parliament at the moment, and there's an experience in one province, a small province in Canada. What we're doing is world-leading work, and it's really important we get it right.
With respect, Premier, your government did flag that 2 years ago it wanted to make these changes. When will people be able to see the reforms that you indicated then that you want to see? When can they actually be expected to have that as a practical lived reality?
Look, that's a really fair question, And it is a little frustrating that that timeline cannot be clearly spelled out today because of the complexity, because of the world-first nature of the work we're doing. And also, should there be legislative change required, that's also in the hands of the Victorian Parliament. The government would, of course, be sponsoring the bill and bringing the bill to the Parliament, but ultimately the time it takes to pass the Parliament is in the hands of the Parliament.
So one of the models that you mentioned there is in Ireland, and they passed laws last October. Part of the laws that were cleared in at least one house of the Irish Parliament brought in a new set of provisions for employers wanting to have an NDA for an employee or want their worker to sign an NDA. So talk me through some of those changes that you want to see here in Victoria as well.
Well, this was where this will be outlined in the discussion paper that we're releasing on the 12th of August. We want to get feedback on a number of potential protections in the restriction of the use of NDAs, and this includes areas like potentially prohibiting the use of NDAs unless they are requested by the complainant. And this is really important in terms of having the victim and their voice front and centre of our considerations. Looking at mechanisms that can address where undue pressure may have been placed to if you like, influence a complainant to enter into an NDA. Also, too, one of the things that has been put to me really clearly in my conversations with victim survivors is that they're often not given enough time. There's a forcing of the decision. There's a rush to get paperwork done, and they're not given time to understand, to work through the complexity of what they're being presented with. So considerations of whether you need a review period or a cooling off period is part of the potential package of changes we're looking at that we're outlining in the discussion paper.
One of the interesting elements of the bill is this idea that employees who have signed an NDA can have the option to waive that down the track. Is that something you want to see in Victoria?
Well, this is something I want to see feedback of, and I don't want to preempt the voices of victims and other people who are involved in the process. This is definitely an issue that has been identified. It's why it's part of the discussion paper that we have released for consultation. I'll be guided by those voices, Harry.
I understand you don't want to get ahead of the feedback process and getting in front of, putting the cart before the horse. But as the Premier, what is your vision at this stage? What is your position? You say you want change. What does that change look like?
Well, the change looks like making sure that victim survivors aren't silenced. That's central to what's driving this next stage of work in my government, is that we shouldn't have legal mechanisms, paperwork being used to silence victim survivors. And why this is important is when you consider, it's a pretty alarming statistic that around 1 in 3 people in the workplace experience a form of sexual harassment. And we know disproportionately they're women. We know too they're disproportionately, it's people from groups that get particularly targeted, like our LGBTIQ plus community. So we know that we need to address this as an issue, which is why I've placed this as a priority for the consultation that we're about to undertake.
Just as a final thought, there are many people, and we don't know how many, but there are many people who have already signed NDAs. What is your plans for them?
Look, that's a real challenge. I would hope that they can feel comfortable to participate in this process. I don't want to cause any re-trauma, but their experience is going to be really important to drive the change, to understand how they've been silenced, how it's been misused, how people have felt coerced. And then the flip side of that is to take that experience and share that with employers, and how together we can work towards getting a better system, better processes that see workplaces more free from sexual harassment, totally free from sexual harassment, but where we can have better supports for victim survivors.
Premier Jacinta Allan, thank you so much for joining the Daily Aus today.
Great to talk to you, Harry. Thank you.
Thank you so much for listening to today's episode of the Daily Aus. It was a really interesting topic, and always great to have the decision makers on the Daily Aus podcast talking directly to you, our audience. If you want to support what we do, hit follow on whatever platform you are listening on or watching if you're on YouTube. We'll be back again tomorrow, but until then, have a great day.